Thank you for joining us for 3Bs on the Law podcast, hosted by Trisha Barita, Camille Canali, and Susan Dawson. Disclaimer, this podcast is for entertainment and informational purposes only, not meant to provide legal advice, and does not create an attorney-client relationship. Also remember, laws change or they differ by jurisdiction, so this is not a substitute for seeking legal counsel in your jurisdiction on the current law applicable to you.
Hi, everybody, and welcome to another episode of 3Bs on the Law. Unfortunately, Trisha's feeling a little under the weather today, so we hope she feels better soon. But Susan and I decided to go ahead and record without her because we wanted to give you an episode this week. And one of the things that we've been talking about but have never done an episode on is contracts and mistakes that people commonly make when they enter into a contract. And you know, the number one thing I think we talked about is people don't read the whole contract and don't know what they're signing. And so I know a lot of people are guilty of this. And I know when we were talking about doing this episode, Trisha had brought up the concept of a lease, which I think is a great example. People enter into them all the time, and a lot of people just don't read it. So they don't know what they've actually agreed to.
Right, which always turns out to be fun when we get those phone calls and they say, well, my lease should say this, and you're like, well, it doesn't. So, but go figure. They're long documents with lots of legal terms, and I can understand why people don't want to read them, and so are a lot of documents. But if you don't read the agreement and you don't have an attorney representing you with the agreement, you frequently don't get what you think you did. Right.
And I know a lot of times, when a client asks me to review a contract, I actually go through all of the contract terms with them and explain it to them in non-legal ease. It's actually understandable by other human beings. Because sometimes the leases are so complicated, it really does take a while to sit down and decipher what's being agreed to. And that's true for all contracts.
It is, for sure. One of the aspects of a lease that I see in other contracts as well that people don't read through is the insurance section, right? So It's very common in leases, but you also see that in a lot of sales of goods contracts and other situations where the contracts will talk about what types of insurance you have to have. There might be a waiver of subrogation claim, which frequently people don't understand what that means. I've seen contracts where, if I'm going to give you a contract, I'm going to ask for the most amount of insurance possible. If you don't read it and double check it, you didn't have to get, $10 million of coverage. I might have been okay with 2. So that's one of those sections that I find people skim over. And a lot of times what I'll do, and I know when we were talking about this earlier, Camille, you and I both have the same approach, is we'll take that section and we'll say, send it to your insurance company. Make sure it complies with your insurance coverage. And ask your insurance agent, is this excessive insurance they're asking for? Is this in line? Because that's the person who knows about insurance coverage on your team. So make sure you've run that one past somebody knowledgeable.
Right. And I think that that is also true with indemnity clauses, which a lot of people don't understand. And it's kind of a big deal because, and here's the thing that we forgot to mention at the very beginning is you can negotiate many of these terms. I mean, depending upon your bargaining power, some landlords have very strongholds in the community and won't negotiate. And that's true with anyone. But here's the thing. If you don't ask, the answer is always no. So if you don't like a term or you don't understand a term, it's okay to ask for a different term. You might be told no, but if you don't negotiate, the answer is always no. And so I digressed for a second, so I apologize.
That's okay.
But I had brought up indemnity clauses, and essentially what that means typically is that you or the other party agree to defend and indemnify, which means pay the damages in a lawsuit or a legal dispute. And a lot of people don't understand what they're agreeing to. And then something happens and they find out that they're on the hook for the other party's legal fees and any damages that may be awarded. And so these can be very complex. there can be contingencies on them. And so it's really important that you understand what you're agreeing to. In addition to the insurance requirements, you make sure you have insurance that covers them, and that if it's a requirement that the other party to the contract be an additional insured on your insurance policy, that you take care of that paperwork and make sure that you've done that.
You're right. And before you sign the contract, you find out what that cost is going to be for adding individuals on as additional insured and getting that indemnity coverage.
Right. And in California, there's actually a case, a California Supreme Court case, Crawford versus Weather Shield, that requires, under many circumstances, if not most circumstances, that if the allegation is in the complaint, would give rise to the indemnity, that you're required to pay the indemnity from the very beginning of the case, or from the time that it's tendered, depending upon the circumstances. And so it's a big deal when you're on the hook for someone else's attorney's fees, because those can often be larger than the damages in the lawsuit.
Absolutely, especially if you don't have a provision in place that talks about reasonable attorney's fees and gives you some ability to maybe veto someone who's going to hire that $1,000 an hour attorney, as opposed to a more reasonable fee in line with your town, what legal fees run in your area, this area of law. So the indemnity section is a big one. Absolutely. Yep. Yeah. So, and again, going through, even when you read it, let's say someone did go ahead and read the whole agreement, or just like indemnity, not fully understanding, there's a lot of clauses that people don't understand what they're signing. So if you don't understand, like, for example, waiver of subrogation, it's a complicated area, and people don't always understand what that means and whether or not you can, will your insurance company allow you to, and what have you done? This is where you need to talk to somebody in other sections similar to that to make sure you understand what you are signing and what you are doing. And back to your negotiation, someone who might tell you, well, this is all negotiable. You didn't have to sign that, right? You could have done something here. So making sure that they don't just sign an agreement. If there's something they don't understand, first find out, don't internet lawyer. I mean, there are some things for sure you can find out on the internet, absolutely, but not, as we know, not everything is accurate there. So doing a couple of searches on the internet isn't always the best way to make sure you understand the contract you're signing.
Yes, as my mom says, the Google doesn't necessarily have all the answers, right? I love my mom. I shouldn't make fun, but
I love it. I think that's great. But yeah, I always know when I've seen someone internet lawyering too. Sometimes I'll get a contract, and you can tell that someone went on the internet, found a couple of templates, and tried to piece them together, and the terms don't match up, and the sections don't make sense. And you can take one look at it and go, "Yep, this was internet lawyered." And a lot of times, the person I'm talking to will fess up to it. And, again, they didn't understand what they were agreeing to. They didn't understand what they were putting in place. They thought they did. Oh, that sounds good. Oh, yeah, look at that. We should probably have that section. That sounds important, without realizing what it should be. So make sure you understand what you're signing and what you're putting together.
Right. And, don't forget to negotiate those terms when you can. Very important.
Right. It's kind of like your document when you're talking about employment law, when it comes to business and contract, negotiate.
You got it. Yeah, I think that's a very important point that a lot of people miss. And, one other little tidbit is, if you are going to have a standard contract for all of your business, like, for example, you manufacture goods and you're going to have a contract with, the people that you provide your goods to, you want to make sure that standard contract has language that works for you.
For sure. You're right. For sure.
Right. I mean, and so it's very important sometimes to have somebody else involved in writing that contract that you are going to use across many different clients or buyers.
Right. Don't just assume that some template you got from somebody else works for your business, because it It probably doesn't.
Yep.
Right?
You got it. And with that, I think that's a great discussion for today, Susan.
Yeah.
All of our points out pretty easily for once.
For sure. I hope everyone out there took something away from these top tips of some of the mistakes that we see frequently. So until next time.
Thank you for joining us on this episode of 3Bs on the Law. Thank you for joining us on today's podcast of 3Bs on the Law. Don't forget to like and subscribe to our podcast. We also welcome any comments. If you'd like to get in touch with us or suggest a future topic, you can email us at 3THREEBsonthelaw@gmail.com. And because we're lawyers, we need to remind you that this podcast is not meant to provide you with legal advice and does not create an attorney-client relationship. Thank you again for joining us, and have a great day.